No, I have your rebuttal numbers here and I'll keep,
I don't want this to look at the quote.
yeah.
Thank you.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You'll be seated. Mr. Confucione?
Good morning, Your Honors. Michael Confucione for the appellant. We're asking the court to reverse the denial of habeas relief by the district court on the ground that the Maryland State Court unreasonably applied clearly established precedent of Strickland. Obviously, I rely principally on the briefs. I'd like to just highlight maybe a couple of things that I think weigh in favor of my position. If you look at the actual Maryland court's denial of the ineffective assistance of counsel claim, which I talk about on page 8 of my brief, I think that's an unreasonable application of Strickland for several reasons. First of all, the Maryland court talks about the defense did not move for a mistrial, but instead decided to move forward with 11 jurors. But the problem with that is it really seems to be assessing whether or not the judge did something wrong. It didn't really talk about the performance of the trial counsel in the context of the situation that existed at the point. And of course, the defendant's claim is he should have asked for a voir dire of the remaining 11 jurors on the panel before he talked to his client about whether or not to proceed with 11 or to opt for the mistrial, which the judge essentially offered as one of the three options. The record
If you
shows.
had a chance for a mistrial in a case that's a murder case, why would you not take it and then wait and see how it developed? You could have a plea, you could have lots of options. Why isn't that malpractice?
By the lawyer?
Yeah.
I think it is.
Yeah.
Especially in the context of this case where it was a blind decision. I think if there had been a voir dire and a reasonable hearing, as it's called, and the facts laid out whether or not the other 11 jurors were prejudiced by what the juror 4 did, and then the lawyer talked to the client about it and said, well, here's our options. There doesn't seem to be any evidence, for example, it could have played out that the other 11 jurors were prejudiced.
And one of the lawyer's defenses to malpractice is that he knew what the jury was going to do. How did he know what the jury was going to do? Nobody knows what the jury's going to do in a murder case.
I agree with Your Honor. And I think that shows that, there's an unreasonable application of Strickland in that regard.
And also, in this case, isn't there a problem with the judge as well in terms of a Sixth Amendment? You have a right to a fair trial, right? And the Supreme Court has said the court has a responsibility to make sure that the jury is not tainted in the Sixth Amendment, because here, right on the faces of it, the judge only asked, the first question was, he read the note, and then he said, tell me what happened. That's just an open-end question. And never did anything. He listened to it, and then he said, well, is this any way going to affect your, and then the witness, the juror, interrupted the court and said, no, sir, not at all. So we don't know what he was answering because he cut the judge off. And then the judge, the next thing was, now go back to your seat. Yeah, he never told the other jurors anything about, whatever you listen to. But here's the thing to me in terms of the record. The problem is, you can see what the lawyer's problem is this. The question is, the juror told him, pretty honest, why did you really go? He said, I went because sometimes you see topographical maps, but I know they're not accurate. I wanted to go there for myself to see what's accurate. And then he said that's what he did. He saw 2 witnesses, didn't talk to them. But here's the key where the lawyer really blew it. Because they said, now, when he asked questions, would you be impacted by this? He said, the juror said, that's correct. I have no problem with basing my decision. And they would have no problem with their decision off of the evidence which was presented. Well, they must have said something to him, because how would he be able to speak for the other jurors? He said, not only me, they wouldn't have any problem. Because what he did was, it's not new evidence he was looking for. He was looking for reassurance because the question was, where was this witness? What was it like? I wanted to see myself. So that's the big taint because it's not new evidence. He said, yeah, now that I've seen this, I can base my decision on what I heard because I've now been assured. And the other jurors must have been too, because then he said, and they would have no problem basing their decision too off the evidence that was presented. Because when he said, for him, the evidence presented wasn't quite enough. I wanted to make sure it's accurate. And the court has a responsibility, and the Supreme Court said in terms of the Sixth Amendment. So not only is the problem, I think, with the idea of a Strickland analysis, but also a Sixth Amendment constitutional question, and that's not necessarily an improper, unreasonable application of facts, but an application of constitutional law. So, I mean, so this case is a pretty serious case.
It's a cogent observation, Your Honor. I mean, I don't want to belabor my oral argument unless the court has questions of me.
So, counsel, the issue of Rimmer, does focusing on that issue, which it seems is your primary briefed issue, has the Supreme Court clearly established that a Rimmer hearing applies in a situation like this where there is a visit to the crime scene as opposed to contact to the jury? Has the Supreme Court clearly established that?
I don't think they have.
Okay.
But you don't have to rely on that in these facts. This is unique. It's not an external. It's like the juror himself instigated himself. You don't need one in terms of everything you need. The problem in this case is right in front of the judge. Yeah, so as a hearing is when you have to say, well, what did the external person say to you and what was the influence and all those kind of things? It's right there. He said they would have no problem. And common sense of that is the only way you could say that under oath is that they told him after whatever he said. And they said they would have no problem either. And I went there to verification, and I got the verification. And nobody ever asked the question about what were you looking for? Why did you go? What was it you wanted to make sure in the court? I mean, this is a life sentence. A life sentence. And then went back and then never told the jury, you should not do anything that whatever you heard, you should disregard it. Never. Just go back and continue your deliberation. Because, so Rimmer is really not really, it's just dispositive in this case.
But that's your primary argument, and yeah, Judge Gregory makes some fair points, but applying the AEDPA standard that we have here, we do look to whether the error was a violation of clearly established Supreme Court law. Don't you agree with that?
I agree with that, Your Honor. I guess I would look at it in this way, and I think my adversary has kind of articulated it correctly. Because it arises in the context of an ineffective assistance claim, the clearly established Supreme Court law is still Strickland. But I do think that the Rimmer right informs the reasonable performance of counsel issue. And in fact, even if Rimmer didn't squarely apply to the circumstances at the trial of this case, even the state law under Nash that the judge cited in the initial habeas denial in the state court, those kinds of principles show that a reasonable lawyer in those circumstances would not have proceeded in the manner in which he did. So I don't know even if you found that, well, there's no clear Supreme Court precedent that extends Rimmer to this kind of a crime scene issue, right, you could still find that the counsel was ineffective under Strickland and that it was an unreasonable application of Strickland by the state court.
Can I switch over to the prejudice element?
Sure, Your Honor.
Don't you have to show a reasonable probability that the outcome would have been different, even if you do show deficient performance?
Yes, you do. And I know that Strickland itself kind of talks about reasonable probability in terms of prejudice, and they talk about the evidence. I think in that case it was a death penalty sentencing issue. But there have been cases since Strickland that I've talked about that you can't just look at the outcome in terms of guilt or innocence, that in a case like this, for example, it's about whether or not as the Sixth Amendment says, the right to an impartial jury was compromised.
But when you say that, the Lockhart case refers to that, but it adds that on top of a different outcome. So it's not in lieu of a different outcome. The Weaver case that you cite is dicta, so we're not talking about clearly established Supreme Court law. We're told we can't consider that. So I don't see the basis for you being able to avoid the reasonable probability of a different outcome. Is there some law that tells me we can do that I'm not aware of or I'm missing?
I think my argument would be that the clearly established Supreme Court precedent does not focus solely on whether or not the defendant would have been convicted. It's whether or not he would have, it's really about the impartiality of the jury.
What
Was that
case,
compromised?
I'm sorry to cut you off.
No, it's all right, Judge.
Did you finish? I want to be
No,
fair.
it's okay. I know where you're at.
I understand your argument, but I want to be as precise as we can. What's the Supreme Court precedent that says we do not have to look to see whether there's a reasonable probability of a different outcome?
Well, I would say, I understand what Your Honor is saying about Lockhart, that it seemed to talk about it as an additional factor. But I guess I would say that Lockhart and maybe even the Nix versus Whiteside or the Morrison case talk about the fairness of an adversarial proceeding. And even in Strickland, I would just add this briefly. I mean, Strickland talks about the right to effective assistance of counsel, and it, in the context of how that effective assistance impacts other rights that the defendant has in the process. And one of the rights Strickland talks about is the right under the Sixth Amendment in an independent clause to an impartial jury.
Yeah.
So I do think you can focus on the fairness of the proceedings. For example,
Go ahead, yeah.
now, just briefly, Your Honor.
Sure.
Like saying that, well, he would have been convicted anyway, even if he had gone for 11 jurors, doesn't really answer the question of whether or not counsel's deficiency in not requesting the voir dire resulted in still preserve the right to an impartial jury. So it's not really about the strength of the evidence. I appreciate that it's a difficult kind of a case on the prejudice prong, because in some sense, we don't really know whether or not the 11 jurors were compromised, one of them at least, because he didn't make the inquiry.
If you do have to show a reasonable probability of a different result, that would mean you'd have to show, it seems like, one of the other 11 jurors was tainted.
Right.
That you would therefore move for a mistrial, and that the mistrial would be granted, and that it would be another trial, and the result is a reasonable probability of an acquittal. All those things, correct?
The second last part of what Your Honor said, I've always kind of had arguments about whether or not you focus on this proceeding, in other words, this trial, or do you focus generally on whether or not if there was another trial, he would have been convicted? I would argue you just look at this trial. Would the result of this trial have been different? In terms of the partiality, I guess what I would say is, first of all, the judge offered a mistrial as one of the options. So the record doesn't clarify that he certainly would have granted it, but it sounds like he would have if it had been requested. I think that goes to the prejudice prong in terms of the outcome of this trial. And also, I think it's kind of significant in terms of whether or not the other 11 jurors were infected, that there was 35 minutes of deliberation with juror number 4 before the note came out to the judge. And the record doesn't show what juror 4 discussed. Even if he didn't say specifically, hey, I went to the crime scene, let me tell you, everything was confirmed by what we heard from the state witness. Even if he didn't say that, the way he participated in the deliberations may have just internally reflected what he already saw. So, in terms of whether or not there's kind of a doubt about whether or not the right to an impartial jury was preserved, I think that there is in terms of the prejudice prong. Also, I know that...
Do you think the judge should have sua sponte mistried the case?
I'm sorry, Your Honor.
Do you think the judge should have sua sponte mistried the case?
I think he should have sua sponte said we have to voir dire the 11 jurors. I think if he found the 11 were not infected in any way and he made a reasonable conclusion factually...
He told the jurors not to do any investigation on their own. And
Well, a mistrial certainly wouldn't have been an error. I'm trying to be as forgiving to the trial judge as possible.
Why? You have a client to represent.
No, I understand, Your Honor. I mean, you can make that conclusion that the judge himself had an independent duty.
But the counsel presented this to the trial judge and I think to the state PCR as a Nash issue, right?
He did, yeah.
And the Nash issue, as I understand the law, you probably know it better than I do, applies once the sua sponte obligation arises once there's a request for a mistrial.
Correct, under the state law of Nash.
Under state law. Under state law that was presented to him, or him or her.
That's correct.
Thank you.
Thank you, Your Honor.
Thank you. Mr. Demiselli?
Good morning, and may it please the court. Andrew DiMaselli on behalf of the state appellees. The crux of Mr. Sweeney's argument is that trial counsel was ineffective for failing to obtain more information about whether juror number 4 tainted the jury before deciding how to proceed in his trial. His argument, however, hinges on the premise that this was essentially free information and essentially risk-free information. That is, there was no downside to asking for a Remmer hearing and inquiring whether the other jurors had heard anything else from juror number 4. But that is not the case, and I think Mr. Sweeney himself demonstrates why that's not the case. He argues in page 7 and 8 of his reply brief that if he had received a Remmer hearing and that Remmer hearing had shown that one or more of the jurors were tainted, the judge would have declared a mistrial on his own.
Well, one of the jurors was tainted because he knew more than the others.
Well, they struck that juror ultimately, and that was something that was a foregone.
But he talked to them, and he assured himself that to the point that he knew what their thoughts were about it. Afterward, he told them. He said they wouldn't have any problem either.
I interpret
That's what you interpret. I'm just what it says. You have to go ahead and interpret it. That's what it says. He said they. He spoke not only for himself, he said they would. Well, in this record, for example, you assume that the only time he talked to them when all of them were present. Well, jurors arrive at different times. Nobody even asked, did you talk to one before you talked to the others? Did you talk to 2 or talk to 3? Nothing. Nothing at all. The man went there because he wanted an accurate assessment, an evaluation of what was seen topographically, because there was a diagram of such as position of where the shooters may have been. Was it not? Was it not?
He said that he wanted to
No,
look
was
at
it
the
not? Wasn't that evidence presented in
Yes.
terms? Right.
Yes.
That's what he was talking about. He said these topographical things, they're there, but they're not accurate. I had to go there. I went there because I wanted to see for myself. And then he said, I have no problem now of basing it on what was heard in the trial because he verified it. He clearly, right? That's inappropriate. You can't enhance the prosecution's case or anybody else's case, the defense case, by something outside on your own. Now I can trust what I heard from that witness stand because I went on my own and I did my investigation. And not only that, I'm speaking for the other jurors. They have no problem with doing that now. The court made no inquiry. And the judge and the lawyer didn't even ask really any questions. He said, you know where I'm coming from. I don't know what that meant. He said, yeah.
I agree with Judge Gregory that the burden of proof was compromised here. The government's burden of proof ends when they rest. And if it's insufficient, then they didn't satisfy the burden of proof. And they have to prove it beyond a reasonable doubt in a murder case.
Well, juror number 4, who certainly was himself tainted, was ultimately stricken from the jury. The real question before the court is whether juror number 4 had indicated.
But you can't have a jury of 11 for a murder case.
Well, he can if the defendant waives his right to a 12-person jury.
No good lawyer is going to do that.
I think that a good lawyer in this case did because, as he testified at the post-conviction hearing, the trial was going really well for them in his perception that they were connecting with the jury.
Did he put on any evidence?
I'm sorry?
Did he put on any evidence? Did the defendant offer any evidence at the trial?
Not in his case, but he said
So there
that
was
he
no evidence from the defendant?
No.
So
in cross-examination,
what was going well for him there?
he testified that he was successful in impeaching many of the state's witnesses, and that he had put on a defense based on his defense about the
And he didn't put on
positioning.
any evidence, and he had to rely on the inadequacy of the government's case.
I think that according to his testimony, he was confident that he was connecting with the jury. He testified that they were
How was he
making
connecting
headway.
with him? You can't just come up and say, I was connected. Did they wink at him? Did they nod? Did they give him a note and say, you're doing pretty good? Yeah, right on. I mean, what does that mean? That's absurd. We're talking about constitutional rights in a murder case and a life sentence, and you're talking about, well, yeah, I nodded. No, you need to find out whether or not what you told him that he could say, they have no problem either. And I went there to verify what was there. And Judge Boyle said it better than I could say it. That really is the important point. That case is over. He became another witness almost for them, perhaps, because he talked to them about what he saw. And he was happy, and I can now do this.
Was he the foreman of the jury? No, he left the jury, excuse me. I understand.
I don't think he was, but in any event, he was
Counsel,
stricken. He
Mr.
ultimately was, sorry, go
Go
ahead.
ahead, no, finish.
He ultimately was stricken from the jury, and the focus on this case is whether trial counsel was unreasonable in his strategic decision based on the information that he received from juror number 4 in advising his client to proceed and not ask for a Remmer hearing.
And what was the information he received from the juror that would make him assured that it was fine?
Well, juror number 4 indicated that he told the other jurors that he had gone to the crime scene and that he had spoken to no one. He saw some witnesses there, and that the other jurors told him to stop. And therefore, on this record,
Because they knew that the judge had told them, you can only consider what's here in the trial. You can't take into account any other evidence at all.
correct. So I think that the record here indicates that the rest of the jurors were not tainted. That's what trial counsel believed. That's ultimately what I think his decision was based on, that he concluded that the other jurors were not tainted based on this colloquy, and that's what he testified to at the post-conviction hearing.
Counsel, there's really not any question, is there, that juror number 4 did something he should have done? We're not here about that. I mean, the question is, is it appropriate, or is it constitutionally ineffective for a trial lawyer to have perceptions about how his cross-examination is going? My colleagues seem to say that's not something that trial lawyers do. I don't really understand that. I think that's what trial lawyers do every day. And a case can go well based on cross-examination, a case in chief, just like it can go well from presenting on your affirmative case. I really have maybe I just have a different viewpoint about perceptions of trial lawyers, but that was kind of how I did it when I was a trial lawyer. And I don't know if he's right or wrong. He might have been wrong here, but it seems like that's the sort of judgments the law says we do defer to people who are in the trenches to make.
I absolutely agree with that viewpoint.
I don't see how it could be. I tried cases, criminal defense cases, for 20 years. And in terms of what was the downside, even if he thought, this I don't know, smoke signals or whatever it was, that he thought it was fine, but to find at least fully what he said to them. And he didn't even ask that question.
I point the court to trial counsel's post-conviction testimony that
I'm not talking about his testimony. I'm talking about the trial. The best evidence is what happened at the trial. The transcript tells it all. He didn't even make any inquiry. And the judge was about to send him back in. He said, wait a minute, can I ask a question? I thought he was going to ask a good question. And instead, he just said, well, are you going to be impacted by, first you ought to know exactly what he said. And people don't speak in the terms of what he said. Well, I told them the same thing I told you. You don't speak in that term. No, I need to tell you exactly what you said and to how many jurors you said it. How many were present? Which ones were present? That's what lawyers do. And you're right, Judge Quattlebaum. Lawyers do it all the time, but they don't do it in the case where they got a tainted juror who sat there with them for at least an hour and talked to them about that. And that you can't, a person's life is on the line. You can't just make hunches that I think it was going well in the case you didn't put anything on. I mean, it's just not even reasonable.
Well, I submit to the court that
You tell me why that's reasonable.
at this point in time, he was at a crossroads where he had to make a decision on how to proceed. It's the
What's the
appellant's case-
crossroad? What is the crossroad?
The crossroad is that it is appellant's case that he should have demanded a Remmer hearing and voir dire the entire.
He should have asked for a mistrial. That's what he should have asked.
They didn't want a mistrial. They
Well,
explicitly
that's what he
did not.
should have. He should have, based on not, if you, in other words, wait, you're right if you ask the right questions. But not asking the right questions, mistrial was his only reasonable way to do it. Yeah, you could do it, and why wait on a hunch when you can say, wait a minute, excuse me, Your Honor, I need to talk, I need to voir dire extension of this. I don't need to know exactly, because common sense, you know jurors don't arrive at the same time. They said they got to be here at 9, some come at 8:30, some come at 1 minute to 9. Did he talk to them in that strata? I said, well, I talked to 2, 3, 4, 5. That's important in a case where you're talking about a person in life sentence in a murder case, and you don't put anybody on. I mean, we talk about, my goodness, the Constitution means something in the Sixth Amendment, and this idea about all we had to find out whether or not it would have made any difference. No. Impartiality of a trial itself offends the idea of constitutional fairness, and that's what the framers did.
But the appellant has not established that the jury he ultimately received and went to a verdict with was tainted. That's the thing. And I agree with Your Honor that he's entitled to an impartial jury, but they struck juror number 4. He was the problem.
But it's not limited to him on these facts.
Well, on these facts,
He
I
talked
submit to the
them.
court that it was limited
Would you
to him.
agree that it's undisputed that he talked to the jurors?
Yes.
Would you agree that it's undisputed there was no question about how many he talked to, when he talked to them, and what exactly he said to them? Isn't that undisputed in this record?
I don't think that the record makes clear how many he talked to or precisely what he said, other than
That's
what he
important.
indicated at the.
Isn't that important if we want to know how an infected juror who talked to them said and what he said to them? Isn't that, you have to do that. Even if he loved that juror, a good lawyer is going to do that and say, well, you know, based on this, he didn't say anything but good morning, I went there, and everybody said, be quiet. But he said more, because he said that they wouldn't have any problem either.
And I interpret that as him saying that they wouldn't have a problem.
That's what he said.
Because he didn't tell them any information about what he saw at the crime scene.
But he did.
He said that he went to the crime scene to get a visual and he saw witnesses there, but he didn't give them any other information.
No,
that
he
would
didn't
have
say that was all he said. He said that he had to tell them, like, I went there. He got out of the car, didn't he?
Yeah,
Okay, where did he walk to?
it's not clear from the
Because
record.
nobody asked him. How close did you get to where supposedly the shooter was? Nobody asked. This is a lawyer sitting there?
But, and Judge Gregory's right, those questions weren't asked, but, but it's certainly not in the record that he said anything to them besides he went to the crime scene.
That's what the record
At
shows.
least that's a fair reading. I mean, maybe you can look at the comment about what they would do, and you could say something about that. I see that point, but I think there's other evidence where you could read that as saying, I just went to the crime scene, and that's all I did. The judge told him not to. The note that came out didn't say anything that we've been told anything other than we went to the crime scene. Now, I think it's a fair point, counsel, that, I mean, it is kind of hard to imagine why you wouldn't say, let me find out from the rest of the jurors. I mean, that's a fair question. Then you have more information to make that judgment call. I think that's the weakest part of the case.
I agree, and I think that that's our response to that is it is not a risk-free proposition.
Why is it not?
Trial count.
But I've already talked about, judgment calls, and so maybe you indicate at least a thought about that. But what's the risk of getting more information from the jurors?
I think as Mr. Sweeney points out in his brief, that could have forced a mistrial that he perhaps did not want.
Why would he not want a mistrial?
Because trial counsel testified that they were satisfied with the way the case was going.
They didn't put on
They
any
made
evidence.
headway that they could not replicate.
They
in
didn't put on
another-
any evidence. They survived the prosecution survived a motion to dismiss at the end of the evidence, and he's anticipating that he knows what the jury is going to do.
I think that trial counsel has to make reasonable assessments of how the trial is going in order to properly
But
advise
they had
his
an
client.
opportunity for a mistrial. You would always take that.
Trial counsel disagrees, and I don't think that that was an unreasonable strategic decision. He decided that based on how they had proceeded in the case thus far, that they were making headway in the courtroom, that they had significantly impeached some of the state's witnesses, and he
Who
was
was wrong?
concerned that he would not be able to replicate that in another case. I mean, this was an extremely difficult case for them because there were numerous eyewitnesses who testified that they saw Mr. Sweeney
Can
standing.
you go back to the thing you said in response to my question, that asking for, doing a voir dire to all the jurors would have forced a mistrial?
I think there was a risk that doing that, if the other jurors had revealed that they had heard something from juror number 4 in addition to whatever he had revealed to the court, regardless of whether it favored the defense or the state, the trial court could have sua sponte declared a mistrial.
Well, wouldn't you
Even if
want
it was
that?
favorable to the
Wouldn't you want
defense.
that? If that's discovered, then you don't want them.
That's assuming that the information they would have revealed would have been favorable to the state. But again, the trial counsel was concerned about losing the gains, the headway that they had made in the courtroom, and that he could not replicate that trial defense in a second trial.
Of course he could. I mean, he had the record of the first trial. He had all the witnesses' testimony. He knew what the government's case would be.
That was his understanding of how the trial was going, that they were connecting with the jury, that they were
No,
making
you
headway.
misunderstood Judge Ball's question. The question is that, assuming that it was going well, he would have the transcript to be able to say, wait a minute, what are you talking about? You said in the previously under oath this. If it was going well, he could assure it would stay in the guidelines well and have done better. It's just no downside to find out whether or not other apples are rotten. And you don't just go and eat the barrel of apples without even testing and see if they're rotten. I don't mean the person are rotten, but I mean in terms of tainted.
Understood.
In that sense, there's no downside to that, because if they're fine, then fine. But if they're not, I'm glad, I did that.
I think trial counsel, he testified that it was his perception, based on his colloquy with juror number 4, that he was satisfied that he did not share the information with the other jurors. And at that point, he had to make a decision on how to advise his client to proceed. And if he had forced a mistrial by going down that road, going down the Remmer Road, he would have lost the gains that he made in that trial.
What gains? What gains? A verdict of guilty and he got life time. What did he gain?
Life in 30 years.
A life plus 30 years.
Hindsight is 20/20.
No, hindsight is not 20/20. Doing what is responsible to do at the point you're supposed to do it is what you do. You're right. No one knows the future, but you deal with the present. And the present was on this record. You have to have found what exactly did you tell them, and to whom, and how many. And I need to know that. And that turns out to be, for example, counsel has an obligation to try. The system is fair. I know you have the harder job because you're supposed to, and I know you do, make sure justice happens. Defense lawyers make sure, in fact, we play by the rules, but their client is exonerated if it can be. But in the sense that you ought not to be, it seems to me the government ought to. And that's what would have been scary to me. If it was going so well for him, look at what the other side does. I didn't hear the prosecution say a word about, well, Judge, we need to find out what they're telling about, because we're worried it may have helped the defense. The fact that they were saying, that's fine, whatever they want to do, fine. And that would tell you right now, it doesn't seem like it was going so well in their mind. If it was, they want to know. But they were good with it.
Well, I think that, again, trial
well,
counsel's perception was not unreasonable, and that's what the Strickland standard requires the court to look
you
at.
can say that, but this record does not support that. It really doesn't. It really doesn't. Not when no one, the judge only asked one question, basically, what happened? And never admonished him. I'm surprised the judge didn't say, well, didn't I tell you not to go? It wasn't even the chastisement. It was all, and he was, as a matter of fact, he told him to go back into the box, and they sat next to him. And the jury stayed out there. I guess it was, the record doesn't reflect, but I guess it was a white noise.
I don't think the record reflects.
Because the jurors were sitting right there watching the bench colloquy. Didn't even take them out. Didn't take them out while they were even questioning him about what he said. Is that right?
That's right. But ultimately, the record does not reflect that juror number 4 revealed any other information. And it is the petitioner's burden to demonstrate under Strickland that, and in post-conviction and under AEDPA, that trial counsel's decision was ultimately deficient and that it would have resulted in a different outcome. And I only have a few seconds left.
He can't show it, but because the ineffectiveness cut him off.
I'm sorry?
The gateway to find out what the full taint may have been was cut off because of counsel's ineffectiveness.
Well, I hate to sound like a broken record, but I think that the record itself demonstrates that juror number 4 did not share any additional information and that trial counsel had to make a reasonable decision in the moment about whether it was wise to demand a Remmer hearing. And in this case, it was not unreasonable. It was trial strategy for counsel to ultimately advise his client to proceed with 11 jurors.
To follow up on your point, assume, I mean, you stated your position, assume hypothetically there's a disagreement on the deficiency prong. Is there any exception to the requirement in an effective assistance of counsel case that the petitioner show there's a reasonable probability of a different outcome?
Not that I'm aware of. I think Your Honor covered this ground with my opposing counsel. The Lockhart case and the Nix case, they add to the Strickland standard. They do not supplant the Strickland standard. And therefore, in all cases, he has to demonstrate a reasonable probability of a different outcome, not just that there's some sort of injustice, that it has to result in a different outcome.
So no matter what the taint is, for example, if one of the jurors say, yeah, I went there, and I'm sure now that what happened is that he did it, right? This is counterfactual. You're saying that if counsel didn't ask for a mistrial, and we're here in habeas, that we could say, it doesn't matter. You would have lost anyway, so who cares that you had a tainted juror? You think that's the law? Is that what you're telling Judge Quattlebaum? You agree that that's the law?
The Strickland standard requires the court to look if there's a reasonable probability of a different outcome.
That can't be the law. There are many cases where people found out witnesses lied, and in cases like the death penalty case, they found out that witnesses didn't tell the truth. They weren't there. You mean to tell me, well, I guess you have to die. We can't, because there's no way, it's no way to show that you would have got another death sentence. That's not the law.
But that's
because there's a constitutional requirement. Because this is a defect. That's why the Supreme Court case talks about the district or the trial judge has a responsibility to make sure there's a fair trial. There's a fair trial, not just because whether or not the person would, just like a counsel has a conflict of interest. We don't say, oh, you had a conflict of interest. It doesn't matter. Your client would have been found guilty anyway. No. There's something structural about that in terms of the foundations of our Constitution. It can't be the law. But anyway, go ahead.
I'm
you finished?
about 3 minutes over time.
No, and I'm responsible for that as lead judge, and we enjoyed the colloquy between us. But right now, I think you finished?
I'm finished, Your Honor. I just asked the court to affirm.
Thank you so much.
Thank you for your time.
All right. Mr. Confucian, you have a few minutes. You have anything further?
I have nothing further, Your Honors, unless the court has questions of me.
Okay, thank you.
I appreciate you hearing the case. Thank you, Your
We'll
Honor.
come down, greet counsel, and then proceed to our next case. You may be seated. Mr. Hess, when you're ready.
Thank you, Your Honor. May it please the court, my name is Todd Hess. I represent the appellants in this matter. I am joined by one of the appellants, Mr. David Glover, who acted pro se on behalf of the respondents in the arbitration that's at issue here today, Your Honor. I do reserve 5 minutes of my time for rebuttal. The appellants filed a petition to vacate an arbitration award that the district court in South Carolina basically denied and instead granted appellee's application for confirmation of the arbitration award. Today I'd like to discuss 2 bases for why we felt like the granting of the petition would have been more appropriate. One is with respect to what we believe was the arbitrator's manifest disregard of the law, and the second is with respect to the arbitrator's failure to provide a reasoned award. With respect to the manifest disregard of the law issue, we felt it appears that the arbitrator failed to draw the essence of the arbitration award basically from the language of the contracts, governing primarily completion dates and ownership of a copyright that my client held in the plans that were at issue in this arbitration.
On the completion date issue, counsel, did you make that a ground in your petition for vacature to the district court?
We did.
Could you identify the place you did that by JA number?
I'm not sure. Primarily, the court itself actually referred to the completion date issue.
So you didn't. So you didn't request that, and your position is the court did it?
Perhaps not directly before the court in the at the district court level, but that is part of the decision that we felt like needed to be made here based upon the district court's use of the completion dates as one of its bases for the order.
Okay. Why is it, can you explain on that issue why, as I understand manifest disregard, you must show that the law was clearly established, that the arbitrator knew of that law, knew it applied, and ignored it anyway, and that there's no way to reconcile any potential outcome, with the award that was rendered.
Our reasoning for that, Your Honor, is basically guided by the Supreme Court as well as the Fourth Circuit in its decision stating that the arbitrator must basically interpret the agreement and exceeds his powers, if you will, if the task of the arbitrator to make the proper interpretation and enforce the contract. He's not supposed to go beyond, if you will, the language of a contract when the language within that contract appears to be unambiguous. We feel like with respect to completion dates, Your Honor, that the contracts were quite clear. There were no completion dates in the contracts, actually. And there are 2 contracts at issue. That's why I used the plural form. But the
arbitrator have felt that an equitable doctrine like promissory estoppel, would justify the reliance of the homeowners, I guess, to the representations about completion date. Seems like that was an issue that was, part of their claims. Maybe assume you're right on the strict contract basis. I think the manifest disregard says there can't be any outcome that would get there. And why wouldn't that be an outcome that could lead to the result that the arbitrator made?
I don't recall that actually in the arbitration award as the basis for the decisions that the arbitrator made was based upon promissory estoppel.
I think you're right. I don't think he explained that, but I don't think manifest disregard standard requires that. Why is that not a viable route to this result that, that could have been the basis of it?
Possibly, Your Honor, but we feel like this wasn't, with respect to the completion dates, that wasn't the only issue with respect to misinterpretation. The arbitrator in this case pretty much just gave the copyrighted plans away basically to the claimants. That was the other issue, and it's clearly stated within the contracts themselves in bold language right at the front that the appellants would maintain ownership of those designs.
And you may be right, but kind of on the same standard. I mean, the arbitrators, I think, said that was, you relied on the testimony that, sure, they had them, and I think that, and showed them to the folks who came in and finished the job, but they said they didn't use them. And in that circumstance, the arbitrator, I think, said it was fair use. And so I think your obligation is to show there's, that pretty tough standard that I mentioned about fair use. And how do you meet that standard given what was done?
Well, again, we do challenge the arbitrator's decision with respect to fair use. I know that is an issue within at least this argument of the case of whether fair use would even be applicable or not. I'm not sure that the arbitrator understood the law surrounding fair use.
But you can't just say he's wrong. You got to say there's no way binding precedent forecloses that he knew it applied, and binding precedent forecloses that absolutely. And you don't seem to be making that type of argument. You seem to say we challenge it, which I appreciate, but I think it's a harder bar than that.
Right. With respect to the fair use argument, we do understand that the arbitrator did make a little bit more, that was the arbitrator's basis. I mean, even before, though, that determination, however, he resisted even looking at the copyright registration that was filed within this case, saying that it wasn't filed within the arbitration hearing itself. It was definitely in his record prior to the arbitration hearing. So he had all the information in front of him. We felt like he had the proper basis to make a decision with respect to copyright, but we believe that he went against the clear language within the contracts, and he gave those plans away to the claimants, Your Honor. And again, if we look at, again, the contract basically reflects that written change orders are required if you want to make a change to the contracts themselves. And there were no written change orders with respect to deadlines, anything like that. And we believe that those should have been required. I mean, the arbitrator admits within the arbitration award that the contracts themselves do not address deadlines. So it would have had to get there by a different way, but it certainly was not made clear to the respondents that it was based upon a promissory estoppel principle. With respect to the special design and custom-built articles that exist, cancellation was pretty much prohibited primarily within the contracts, primarily because designs were involved, ordering of equipment was involved, and that would have made cancellation very, the respondents would have had to pay a high price for that. I'd like to go ahead on, if I may, and discuss with you the second issue that we felt like exists here. That is with respect to the reasonable award decision. The AAA commercial arbitration rules in effect at the time basically provided two reasons for why a reasoned award was appropriate. In this case, the arbitrator appears to have made the decision that reasoned award would have been appropriate, which was allowed by the AAA rules at the time, and he made that clear within the preliminary hearing and scheduling order that was issued in the arbitration, that it should be a reasoned award. Why
isn't this one reasoned?
We We feel like under the standards right now in the Fourth Circuit, most of the district courts rely upon the North Dakota, Illinois District Court decision. It's a decision that was made, I think it's back in 2005, and that decision itself is not clear on, we don't feel clear enough on what a reasoned award is. And that's why we look to the what's happened in the Fifth Circuits, the 11th Circuit, the Second Circuit, and the Third Circuit. They've all adopted the same. The 11th Circuit clearly recognizes that the Federal Arbitration Act fails to clearly define what a reasoned award is. And I think that the 5th, 11th, 2nd, and 3rd Circuits felt like there was a need to define that and provide that definition. And they had, in fact, done that. I mean, if we look to the Leeward construction decision that was provided by the Second Circuit.
Right.
The Leeward decision says that a reasoned award is something more than a line or two of unexplained conclusions, but something less than full findings of facts and conclusions of law on each issue raised before the panel. A reasoned award sets forth the basis reasoning of the arbiter panel on the central issue or issues raised before it, but it need not delve into every argument made by the parties. What we have,
If that's the case, I appreciate that, and I think our law isn't real clear. Maybe this is a case where we define it, but assume, is that the standard you'd like us to adopt?
that's certainly our recommendation, Your Honor.
If it is, why would, in this case, you got, 4.5 pages of background and facts, then from page 5, through 7, you have the arbitrator explaining the basis of the award. So just using the standard you just said applied, it's more than a line or two of unexplained conclusions.
In particular, what we're looking at is we're looking at the 9 counterclaims that were raised by the appellant, Your Honor. If you look at the arbitrator's reasoning on the 9 counterclaims, you'll see that for most of those counterclaims, with the exception of the copyright issue claim where he did actually go into fair use, as we previously discussed, the remainder counterclaims were just conclusory, single line, if you will, single phrase statements stating that he did not find a basis to grant the counterclaim without any further reasoning at all. So we feel like, at least with respect to the counterclaims at issue, that the arbitrator would not have met this standard if it was adopted by the Fourth Circuit with respect to reasoned award. Secondly, while the district court found that a failure to provide a reasoned award, there was not enough basis, if you will, to grant vacatur, the Second Circuit has also addressed that, and in fact, a South Carolina District Court found, consistent with that, a failing to provide a reasoned award, if there was no other basis, if you will, for finding a barely, what they used as language called barely tolerable justification for why an outcome was reached. If that basis is not in there, we don't see that in there at all within the arbitrator's award, then vacatur would be appropriate. So we do then believe that the arbitrator's cursory single-phrase conclusions for each of the counterclaims, again with the exception of the copyright infringement issue, that he failed to establish a basis for each of these counterclaims, and it doesn't arise to the standard required, if you will, by the 4 circuits that we discussed, that it provides the additional information needed to make a conclusory, something other than a conclusory statement on those counterclaims.
Counsel, can I just make sure I'm understanding and reading the award the same way you are? It looks to me like your complaint seems to be primarily about the counterclaims, and I'm sure not every counterclaim is addressed, but just in terms of the award itself, doesn't the counterclaim discussion begin at the top of page 6?
From what I recall, yes, Your Honor.
And it goes through the second, about half of page 7?
Yes, Your Honor.
So, okay. Thank you.
So we do then feel like vacatur of the arbitration award is warranted in this matter. We feel like that the this should be remanded to the district court with instructions to at least look at the arbitrator's award to make a determination on whether vacature is appropriate. We feel like it is, but we feel like that does need to be decided at the district court level. So we would ask that it be reversed and remanded for their look-see, Your Honor. With that said, I think I'm almost out of time. I'll go ahead and defer to my rebuttal later.
Thank you, Mr. Hess.
Oh, thank you.
Yeah, thank you. Mr. Walden?
Good morning. May it please the court. My name is Andrew Walden, and I'm here on behalf of the appellees. I'm honored and humbled to be before you today, and I'm here to ask that you affirm the district court and uphold the arbitration award. As this court knows, overturning or vacating an arbitration award has a very high standard. Your honors are limited to determining whether the arbitrator did his job, not whether he did it well or correctly, but simply that he did it. As this court stated in Warfield versus Icon Advisors, it would be a Herculean task to overturn an arbitration award. Because the arbitration award can only be vacated on very specific grounds, statutory and common law, this court has to make a few decisions, and I'll address what my opposing counsel stated as far as a reasoned award and then a manifest disregard, and I'll take them in reverse order. So this court needs to determine from a reasoned award standard if the arbitrator issued an award that was definite and final. And there are two standards that are being discussed in this case today, and I heard you loud and clear, Judge Quattlebaum, when you said that this court may take this case in order to define what a reasoned award is in the Fourth Circuit. And the reasoned award is not defined in the Fourth Circuit. However, we did have a standard that was before the arbitrator that heard this case, and that standard was that the arbitrator, when he deduced his award to writing, that he resolved all issues before him, and that he did so in a clear and unambiguous manner such that a court such as yourself can have a meaningful review. He clearly met that standard, the standard that he had in place whenever he was issuing his award. Also, I would agree with my opposing counsel that the AAA does not, or American Arbitration Association does not have a defined standard for what, or definition for reasoned award, but it falls somewhere in between standard award, which is a simple result, and full findings of facts and conclusions of law.
Do you have a standard for reasoned award if we elect to address that in any opinion that we might write about this? Do you have, or your client have a position for the standard we should adopt?
Your Honor, I think we even said it in our brief, we're fine if this court chooses to adopt the Second Circuit standard. We think even under that standard, that this is a reasoned award by any means of any realm of the imagination. So the Second Circuit, and I'll speak about Leeward briefly, that's where this standard came from, said that a reasoned award must be more than one or two sentences of unexplained conclusions, but something less than full findings of facts and conclusions of law. Essentially, it falls right where the AAA already kind of outlined in between. They have you on the preliminary hearing circle, which award you'd like. It falls somewhere in between those two spectrums.
Sounds like criminal sentencing.
Yes, sir. Well, unfortunately, sir, I've never been a criminal lawyer, as I know that you guys have, so I wouldn't know that. However, I will say that unlike what my opposing counsel says, it doesn't stop right there. The Leeward case goes further and says that the arbitrator needs to discuss or needs to resolve the issues before it. He needs not delve, or he or her needs not delve into every issue or arguments raised. Merely that the arbitrator needs to resolve the issue. So the Second Circuit standard, the way we read it, is consistent already with what the Fourth Circuit is using today. But to answer your question directly, we would have no problem if you were to adopt the Second Circuit standard through this case, Your Honor.
Can I shift gears with you?
Yes.
And I may be getting you out of the argument you want to go in, or the order you want to go in. But the argument that your colleague made about a completion date, the arbitrator said termination was justified, and it cited to representations that the record that arbitrator said supported that promises had been made about this date, that date, and another date, I think. But the contract, I think it's fair to say, doesn't have a completion date. and the contract has an integration clause. So it seems like verbal promises, are things that that wouldn't be permissible under that, at least under the contract. So just, I raised some equitable issues and stuff like that, but just on the contract itself, is there any way in a breach of contract case that has no completion date and has an integration clause, you can rely on oral statements to create a completion date? As a matter of contract law?
As a matter of contract law, Your Honor, I don't know if it's necessarily been briefed, but there can be, if there is no deadline in a contract, then a contract needs to be resolved within a reasonable amount of time. And so I think that's what and this actually raises an interesting point because I believe.
So say that the law, is this South Carolina law?
Yes, Your Honor.
So South Carolina law, and I'm from there, so I should probably know, but I trust you. The law of South Carolina is that if a contract doesn't have a completion date, it needs to be completed with a reasonable amount of time?
Yes, Your Honor, I believe that is correct. Now, but this also raises an interesting point, and I'll just go ahead and switch gears here because I believe that we've already established that there was a reason to award. From the manifest disregard of the law standard, this court actually said in the MCI Construction LLC versus City of Greensboro case that to allow I missed my place, but basically the quote I was going to read said that from a manifest disregard of the law standard, that based on the heightened scrutiny, the decision essentially stops there because they have to prove that the law is well known and settled and that the arbitrator expressly disregarded the law. So whenever you look at it from the context of this arbitration award, he in the arbitration award, he talks about the completion date. The lack of a completion date. And he said that, then went on to say, but due to these additional promises and failures to meet these promises, that that there was justified termination of these contracts. So he arguably is construing the contract, which is all we need to prove today for you guys to uphold this arbitration award. Also, I think that this, from your first question to opposing counsel, I don't think this has been reserved for review on appeal. I think manifest disregard of the law and whether one is meeting the essence of a contract are two different standards of review and two different issues before the court. So from a manifest disregard of the law standard, that he has to show that the arbitrator did not or either inserted his own terms for his notions of fair, point, and justice, or whether he took the terms that were there and misconstrued them in some way. Here, he didn't do that. He didn't insert his own terms.
Let me. If you talked about the forfeiture issue, and I want to follow up on that. Assume they didn't raise this issue in their petition for vacature, and their response is, well, the district court, in its order affirming the award, addresses that point in an erroneous manner. You may agree with that, you may disagree, but as a matter of just how we handle forfeiture, if a district court addresses a forfeited issue in a way that a party thinks is erroneous, is that fair game on appeal?
I would say that in the district court, if an appeal is coming from the district court and in passing an issue was mentioned, then unless the appellant makes it as a point in his appeal, then
well, he does in his appeal.
Sir.
I think it's debatable whether the district court did. I think you could say he's just stating the standard and not doing something outside what the parties presented. But I'm just thinking hypothetically, if I get forfeiture, but if it's kind of odd. It's kind of odd that if the district court were to hypothetically issue a an order on something that is erroneous, that we just kind of look the other way just because before then it was not raised?
Your Honor, the answer to your question for me is I don't know. However, the reason I don't know is because I don't think it matters here. Even if you guys, Your Honors, were to take up this issue, this arbitrator arguably construed the contract. And so this award has to be upheld. And that sort of switches back to the reasoned award issue, which is one of the points that that my opposing counsel, or that the appellant would like this court to determine, is whether or not the counterclaims that were asserted were addressed in a reasoned manner. As Your Honor noted, there was 2 pages of text that discussed that. Part of those 2 pages of text were talking about the appellant's failure to provide any proof for the claims. And I don't know how you get much more reason than explaining that through the evidence submitted, there was no proof offered. And that sort of is a good segue into this issue that's in the brief that wasn't discussed necessarily by the opposing counsel, but they make this issue in the brief about this registration statement and about how the arbitrator did not review the entire record in coming to his, and that it is defined and specific to this copyright registration statement in their brief. Briefly to that point, it's sort of a moot issue, a red herring, because the arbitrator, he did indicate that the registration statement on the copyright issue was not put into evidence, but then he went on to say there was a semicolon, and he said, however, it would not have made a difference in how he came down with his decision.
That's a procedural objection, I assume, not to the extent it wasn't considered. It's a procedural objection by the petitioners?
Well, I believe that, Your Honor, I believe the appellant's saying it's a manifest. Well, that actually back to, I think I might have conflated the 2 issues there. Back to, I think they put that issue under a manifest disregard of the law, and they are saying that failure to consider the entire arbitration record, every document generated during arbitration. If the arbitrator did not consider every document, then that's grounds for vacature under a manifest disregard of the law. We would obviously disagree with that.
I guess my point is, I thought the law for procedural errors alleged regarding arbitration was that they only can be overturned if they were in bad faith or so gross as to amount to affirmative misconduct.
Your Honor, that is correct. I was just trying to address it in the context of how they appealed it. Your Honor, I've jumped around a lot. I've talked about reasoned award. I've talked about a manifest disregard of the law. I think, again, as I previously stated, that the burden is extremely high. I actually tried this arbitration. I was there. I think he gave great deference to the appellant. I think there was 3 days of hearing.
How long did it take?
It was a 3-day hearing, Your Honor. There was numerous exhibits presented. We presented numerous witnesses from the appellee's side. The appellant presented only 1 witness himself, for both expert and for fact witness, and he took up the last day, maybe day and a half of presentation. So, and he did a great job. At the end of his argument, he motioned to dismiss. At the end of my case in chief, he motioned to dismiss. He zealously represented himself and the other parties from the appellant standpoint. That's why I know the arbitrator got this right.
So there was full and adequate process, you're saying?
Absolutely, Your Honor, and that's the 3rd issue in their appeal, is that they want this court to find that there wasn't a fair and adequate opportunity for the cases to be heard. And, Your Honors, I believe it's Joint Appendix page 121. The arbitrator, which is a part of the arbitration award, the arbitrator asked us all at the end of the hearing, did each party have a fair and adequate opportunity to be heard? And we all said so in the affirmative. I believe it'd be wasting your time for me to quote from the arbitration award, but that's in the award. He asked it. We all answered that we had our opportunity. One observation that isn't in any of the briefing before I finish my argument is, I believe it's Joint Appendix 364 to 66 or 366 to 68. When it came time for the parties to present proposed orders, the appellants presented a 3-page proposed order, one that anybody objectively would review or view as a standard award. It wasn't a reasoned award. It was 3 pages, and it essentially had blanks to add in the amount of money. So I find it a little bit disingenuous that they're here saying that there wasn't a reasoned award whenever the proposed order they wanted the arbitrator to sign was only 3 pages, really 1 page after you get past the caption and the signature blocks. Subject to any questions you have, Your Honor, I've sort of addressed the 3 issues in their appeal. Our appeal, I believe our briefs were well briefed, and certainly they are primary over my arguments.
Thank you, counsel.
Appreciate the opportunity to be here.
Certainly. Mr. Hess, you have some time reserved.
Thank you, Your Honor. I'd like to use the remaining time to maybe address some of the issues that seem to be outstanding within here. I do know that opposing counsel here had talked about the arbitrator not inserting his own terms. We do feel like that the arbitration award, the Fourth Circuit has determined that an arbitration award fails to draw its essence from the agreement when an arbitrator disregards or modifies the unambiguous contract language. Doesn't go into promissory estoppel that I've seen, at least with any of the case law addressing this, that I could find.
That case, counsel, I think, is the Advantage Veterans case.
It's the Choice Hotels case.
Choice Hotels,
from,
okay.
Yeah,
Okay.
from 2008.
All right, thank you.
And they further look at it actually in a case that is more likened to this case in Patent versus Signature Insurance Agency. If you look at that one, it clearly states that the arbitrator disregarded the plain and unambiguous language of the contract governing completion by implying that there was a 1-year limitation period within that contract when the contract at all didn't say that. So we feel like that's more like in here. We were in a period when these contracts were being executed, obviously. It was the COVID period, and that's when things were difficult to acquire. Services were difficult to obtain on it. So if there were like verbal like assurances that I'll get it done by this date, I can assure you it was mostly, it was a little bit more universal in terms of the forces that were acting upon.
Did you make a force majeure argument with the arbitrator?
We did not, Your Honor. No. So, but we do feel like that it was clear that there was not completion dates within the contract. We feel like that the arbitrator went ahead and felt like that he needed to add those, obviously, to be able to make his case. And his case indeed was based upon the failure, and he clearly made this statement. He said that failure to meet any of these deadlines is in essence good enough for him to go ahead and cancel the contract. Use that as a reasoning, even though there was a cancellation provision that prevented that within the contracts itself. So with respect to the district court's final order concerning the arbitrator statements, we did refer to JA 509, actually. If you look at that, the district court's basis in their order and opinion for determining that in part of their decision, they basically said that the appellant's repeated failure to meet the many dates promised for completion justified termination of the contracts. He's using that same statement that the arbitrator made, that we quite frankly disagree that the arbitrator basically had the ability to make that kind of statement given the language within the contracts, Your Honor. With respect to the counterclaims, we feel like that those go beyond issues that were being taken up by the arbitrator. We felt like the counterclaims, they were clearly claims, 9 of them, in fact, that were made by the appellants. If you look at the page and a half of the arbitrator's award that does cover counterclaims, you'll see that the first paragraph, about half of that paragraph just goes to basically conclusory statements stating that the appellants have failed to basically show those. Most of the other language that's remaining goes to the copyright infringement issue. And again, we've highlighted that as one of the issues if there was actually a reasoned award, it was probably on the copyright infringement issue, although we disagree with it from a standpoint that the contracts itself state that the appellants continued to own those designs. But the arbitrator did rely upon the fair use argument, and that occupies quite a bit of that space with respect to counterclaims. So we feel like the counterclaims themselves go beyond issue, and they at least deserve something more than a conclusory statement of stating that the appellants failed to meet them. With that said, it looks like I'm out of time, unless the judges have any other questions.
Thank you.
Thank you.
Thank you both. You want to take a break? Yeah, right. Yeah, we're going to proceed to greet counsel and then take a brief recess.
The Honorable Court will take a brief recess.
You may be seated. Schnetzler?
Good morning, Your Honors. May it please the Court. Nathan Schnetzler on behalf of the appellants, Arlethea Pack and Armor Correctional Health Services. Your Honor, as is laid out in the briefs, the critical issue in this case for this Court to determine is whether or not, under Virginia law, in a medical negligence case, there was sufficient evidence for the jury to find that Nurse Peck proximately caused injury or the death of the decedent, Mr. Boley, who was an inmate at Deerfield Correctional Center at the time of his death.
Counsel, isn't the first issue whether we look at this for sufficiency of evidence or for no evidence based on whether or not your 50A motions forfeited this issue?
That is an issue that has been raised, Your Honor, by the appellees, and the district court raised it as well. Obviously, we disagree on that, on both with the district court's analysis and with the appellee with respect to whether or not there was actual forfeiture in this case. The reason being, Your Honor, is that with respect to Rule 50A, when the motion's made at trial, I think the court, the Fourth Circuit specifically, has said that the rules of civil procedure need to be interpreted broadly and liberally. And I think it's incredibly important in this context at Rule 50A, as trial counsel is trying to make an argument with respect to a motion for judgment or directed verdict, that the court grants leeway when that motion is refiled as a Rule 50B motion. And the reason being is that those arguments are made in the heat of trial, oftentimes not with the sufficient opportunity to prepare those arguments or with the benefit of a transcript. And so looking at that issue with respect to whether or not there even was forfeiture in this case, our argument, Your Honor, is plainly looks to whether or not the opposing party had noticed really in an opportunity to
How would
respond.
I mean, I appreciate the liberal construction. I think that's fair, and I appreciate the intensity and the, of being in trial. I think that all that is fair. But in reading the 50A motions, really both of them, there were two, both of them seem to totally piggyback on Dr. Harris's motions about the contingencies of what could happen at the ER. Not once that I saw was there a motion that was peculiar to Nurse Peck. There was nothing about the need for expert testimony to Nurse Peck or about how she specifically, her violation of the standard of care didn't cause. Now, maybe we could say any mention of causation encompasses anything of causation, but that's not just liberal. That's pretty wide open.
I agree, Judge Quattlebaum, but in that sense, the issue of causation, obviously a critical element in particularly in a medical negligence case.
Right.
In where I would point the court to with respect to the record is trial counsel did reference causation multiple times with respect to all counts and with respect to both defendants, Dr. Harris and Nurse Peck. Armour was just a defendant for purposes of responding superior. But with respect to the arguments that were made by trial counsel, he was clear that he was making a broader motion with respect to causation. He talked about the speculative nature that Boley would have lived, which is important because that goes to the issue under Virginia law as whether or not the breach of the standard of care, when you're talking about proximate cause in a medical negligence case, one of the issues the court has to consider is whether that breach, in order to reach the proximate cause prong, affected the substantial probability of survival of the decedent. And that is where I think is critical.
But your argument in the 50B motion and to us is that there was no expert testimony about causation as to Nurse Peck. There, of course, was expert testimony about causation as it applied to Dr. Harris. The jury apparently found it persuasive that evidence. They found for Dr. Harris, so they considered those arguments and things. But anyway, I don't want to beat a dead horse, but I mean, the arguments you're making now about causation seem to be of a distinct character from the ones that were made at trial. And I don't think that means you can't go forward. It just means you have a no evidence standard versus a sufficiency standard.
Right, Your Honor, and as the appellees have conceded, even if the court were to find that the district court was correct that there was forfeiture, the court could review it under a plain error standard and determine whether or not, from our position, that would then turn on to whether or not there was manifest injustice based on the lack of any evidence with respect to that proximate cause prong as to Nurse Peck in this case. And again, it just, Your Honor, with respect to the standard of review that this panel needs to apply here, I think it's important to note that the appellee was certainly on notice that causation was part of those Rule 50A motions. It's an essential element of the claim, and therefore that there was an opportunity to respond to those arguments at trial. There was an opportunity to respond to those arguments at the Rule 50B stage. And I think it's important also, perhaps not as important with respect to what was actually presented to the trial court at trial, but the fact that the trial court essentially went ahead and did a full review rather than just saying, no, you forfeited this argument, I'm not going to consider it, I think is also persuasive that this court should consider a de novo review as well and should apply that standard to determine whether or not there was evidence on that proximate cause.
Well, at the trial, the nurse and the doctor had the same lawyer.
That's correct, Your Honor.
So, and you couldn't argue that there was an intervening negligence on the doctor's part.
Correct, Your Honor.
That was a problem, though, that, see, you had different interests, didn't they? Well, you want to use it now, and now he's been acquitted, you want to now say, well, the intervening cause was the doctor.
No, Your Honor, we're not making a superseding intervening cause argument.
Are you not?
We are not making that argument. I think we've been very clear both with the district court and in our briefs in this case. The argument's not superseding intervening cause with respect to either the other nurse that saw Mr. Boley and provided treatment.
I'm not talking about the other nurse, I'm talking about the doctor.
Yes, Your Honor, and so our argument is not with respect to either of those two medical professionals that were providing treatment to Mr. Boley over the next several hours of the evening. Our argument is that the court can consider that because the evidence in the case from the plaintiff's side of the case was that the standard of care for the physician was to send Mr. Boley to the ED, to the emergency department, upon hearing about these complaints of chest pains, of the worst chest pain of his life. And the plaintiff's evidence was that the failure to do that was a breach of the standard of care and that was the proximate cause of Mr. Boley's demise. But the jury rejected that. So we're not arguing that there was a superseding intervening cause. What we're arguing is that the court can consider, to the extent that it even thinks that there was sufficient evidence on the proximate cause prong to go to the jury rejected that theory by finding in favor of Dr. Harris. And so by finding that there was no proximate cause with respect to Dr. Harris, it really makes no sense that a jury could find that the nurse, the LPN, Ms. Peck, that even if it did find there was a breach of the standard of care, that breach could approximately cause Mr. Boley's death. It's a bit, I understand the nuance of the argument. You really have to sort of sit down and wrestle with the issues. But if the jury rejects that the proximate cause of the death was the failure, if the jury doesn't believe the plaintiff's argument that proximate cause of the death was the failure to get him to the emergency department, if they reject that theory, how
But we
can
don't
they-
know what they rejected. They just, maybe we do. Maybe there's a specific verdict. But if it just says I find some, I should know this, and maybe it's in the record. But if it doesn't say causation, they may have said no breach of a duty. It may not have gotten the causation.
Where actually the verdict form is in the joint appendix.
Does it
Judge
say
Quattlebaum.
causation?
It is. And
Okay.
well, it does not say causation. It says, do you find that Dr. Harris was negligent? And that was it. And it says but But the jury instructions, which are also included in the joint appendix, were clear about what the elements were and what needed to be proven with respect to the negligence, that you had to have a
But
breach.
you can't say that the jury relied on your causation arguments to Dr. Harris if the basis for their decision was he wasn't negligent in the first place.
I think it cuts both ways, Judge, because if it's just a simple verdict of Dr. Harris was not negligent, we have to determine, okay, well, what's the standard, what are the elements of the claim here, right? And you had to either have a breach of the standard of care along with proximate cause. And so they could have found there was no breach of the standard of care.
That's right.
And it's the same argument with respect to Nurse Peck then. If there was no breach of the standard of care by Dr. Harris of not sending Mr. Bowley, then how can there be a finding as to Nurse Peck? And that's where this argument really, like, you have to sort of drill down into what the jury did in this case and why we're not arguing that this is a superseding intervening cause. The argument is more drilled towards what, and I would point the court to the Jenkins versus Payne case from the Supreme Court of Virginia, and it's in a footnote, but it notes that there's no problem with defense counsel pointing to another medical provider's actions. You know, there was the issue in that case is whether that defendant could say that the other medical providers were negligent, and the court was not going to allow that. But there was nothing wrong with the defendant in the Jenkins versus Payne case referencing the other treatment that was involved. And I think that that's where we have to consider this case falling along those lines. And it actually goes, I think, an even step further than all these cases that we've cited in the briefs, in that we have this nuance that really is a distinct issue, that you have a Nurse Peck who is alleged to have apparently one encounter with Mr. Bowley, and then you have subsequent treatment by medical providers that a jury found were not negligent. And so that, to me, should give the court pause for concern when a jury's finding that the physician was not negligent for failing to send him out.
Yeah, but oh, go ahead.
I'm sorry.
I mean, I think I get, your argument, and there's some appeal of it to me in this sense. I mean, obviously that before settlements, there were, claims against all these nurses, and, after settlements, lawyers do what they do. They kind of, recalibrate and have a trial strategy, and the testimony of Dr. Bethay, is very clear, I think, that, just the information about chest pain, blood pressure, and pulse was enough to cause Dr. Harris to have to send the patient to the hospital. Really, completely disavows anything that Nurse Hayes might have done inadequately. So it seems then for Nurse Peck to have caused this, there would have to be expert testimony that Nurse Peck would have provided different or more information, and I don't think there was any, and so that's sympathetic to me. But the hard thing, though, is, and Judge Gregory alluded to this before, is it looks like the trial strategy was to link Nurse Peck to Dr. Harris and not make any arguments really specific to Nurse Peck. And then once a verdict that was probably unexpected comes out, you're making arguments that the district court never really had a chance, at least into the 50B motion, to consider. So it's just maybe there's no evidence, but it's just, I mean, it's kind of tough to do that for the first time after it looks like your strategy is we're just going to, piggyback Nurse Peck onto Dr. Harris.
And to circle back on that standard of review issue, Judge, I think it's important that trial counsel did ask the district court if the district court had additional questions about the causation issue. And that colloquy during the first Rule 50A motion at the close of plaintiff's evidence is critical, I think, because, again, if the intent of the rule is to provide notice to the opposing party, and of course, the trial judge to address what the heart of the argument.
But what he did, I don't mean to cut you off, but that he did say that, and I'm not suggesting you're, being misleading or anything, but before he said that, he said, I referred to causation earlier, and if you go back to what his first 50A motion was, again, it was all about what might have happened or not happened in the emergency room, which was basically a Dr. Harris issue, and it wasn't this issue of expert testimony. So, I mean, asking a district court, do you have any questions about causation? I mean, that's a bit, I mean, I'm not sure you're putting everyone on notice that you have this theory that you haven't articulated yet.
I think, Your Honor, that trying to get that issue fleshed out with the judge, so that the judge is clear as to what your argument is important, and I think trial counsel tried to do that. I know opposing counsel at trial, in response to defense counsel saying, I don't think that the plaintiff addressed causation in their opposition to the first Rule 50A motion, plaintiff's counsel offered to address it with respect to the trial judge. I think there would have been further opportunity to develop that issue, but it wasn't. And I think trial counsel, to his credit, was trying to make a Rule 50A motion on behalf of two defendants on, I believe it was 3 separate claims that were still pending in a very tight timeline. I see I'm run out of time.
But you're good, but again, isn't that the risk you take when you decide to represent all 3 defendants like that? Because that is like in the criminal cases, when you have people and witnesses and those kind of things, and you have to have separate counsel because there may be a conflict, because you had no interest in doing anything in the trial, right, to point to the nurse separately that, well, she didn't do anything because she couldn't have been, because whatever she did in delay, a physician saw him, and that would cut off any causation, right? You were happy with that, right?
I think that I was not trial counsel.
I know,
my firm was not, but I believe
saying,
that was sort of I know I'm over, if I may respond.
Yeah, but isn't that right? That's what you really want to do. And now you want to come now and say, wait a minute, now he's clear. Now we can then say, well, she couldn't be negligent because he took care of all of that. And now, basically, you're saying it's an inconsistent verdict?
It is an inconsistent verdict. It is.
That's the problem. You're telling me that because they found a general verdict of not guilty based on, not guilty, but not liable based on a lack of negligence, she, as a matter of law, couldn't be also negligent?
Based on the testimony that was that came from the plaintiff's case, Your Honor, because if you look at the standard of care with respect to Nurse Peck, Nurse Roscoe was very clear what the standard of care required, and there were four things that Nurse Peck should have done according to Nurse Roscoe. It was ask questions about the chest pain and the patient's medical history, obtain the patient's vital signs, conduct a physical exam, and then report that to whoever the supervisor may have been, whether it was an RN or whether it was Dr. Harris or somebody else. That information should be reported. There was no testimony that Nurse Peck had any duty or that was within her standard of care to make an independent decision to send Mr. Boley out of the facility to the emergency department.
But then you should have just a motion to strike. Basically, there was no evidence against her at all. But was evidence that there was a breach of the standard?
There was evidence. Yes, Your Honor.
Yeah, it was, but
Yes, she didn't seem. Well, Judge Gregory makes a point I hadn't thought about, and you mentioned it, the inconsistent verdict. Did you make an inconsistent verdict motion? Or not you? Did trial counsel make an inconsistent verdict issue?
There was no motion.
So there's no, I mean, we have there's a debate about whether you made an appropriate 50A motion. There's no inconsistent verdict motion, and so all this kind of comes at the end. Okay.
So jurors are reluctant to bring back a big verdict against doctors. That's a known factor. And so, but they were outraged at what happened. And so the nurse got hit with the verdict.
I think that's what happened, Your Honor. I think that there was, to speculate what happened in that jury room was that there was some anger directed at Nurse Peck, and as Your Honor mentioned, Judge Boyle, that there may have been reticent to find against the physician in that context. But it's the court's obligation to determine whether that jury verdict is in accordance with the law. And for the reasons I've stated, I would ask that the court reverse.
But you would say, now, I know your first argument is that there's insufficient evidence, but you would also say there's plain error because there's no admissible evidence at all about how Nurse Peck caused Mr. Bowley's injuries and death?
Correct, Your Honor, because it is an essential element. We think that it would even fall under a plain error standard review of warrant reversal.
All right. Thank you. Mr. Zanlon?
Morning, Your Honors. My name is Danny Zemmel, and I'm here on behalf of the appellee, James Bowley. I'd like to start with three things I'd like to go through that were mainly discussed here on the Rule 50 motion for a judgment of a matter of law, and that would be the waiver, the idea of an inconsistent verdict, and the fact that our argument for why this was not any error, certainly not plain error.
What kind of custody was your decedent in?
He was an inmate at the Deerfield Correctional Center.
Which is a state facility?
State facility, yes, Your Honor. Department of Corrections for the Virginia State Facility. So I'd like to say quickly on waiver that all parties were well aware of what the causation argument was here and as to what Armour's counsel at the trial's argument about Nurse Peck was. In his opening argument, he stated, "I haven't said much about Nurse Peck, and that's because it's our position that she never saw Mr. Bowley on April 16th and that she certainly did not disregard any complaints of serious and obvious chest pain." And that continued throughout the trial. Her defense was entirely about liability, that she did not see him at all, or if she did, he did not say anything about chest pains. And so I think the idea that there was any specific proximate cause argument was not brought up. And it is true that causation was said many times, but again, as I think Judge Quattlebaum noted, there was a specific pretrial causation motion filed by Armour about, as the district court judge put in his motion, the granularity or specificity needed about what specific people at the ER would have done. That was argued in pretrial, in the directs and the crosses of all the experts through Armour's, and then through the Rule 50A motion. All parties knew what causation meant in this standard.
How long did the trial take?
It was 5 days in total, Your Honor. Although the first day was mostly voir dire, it was a 5-day trial through which the district court saw all this. Also, this beforehand, this had been a long case, had been going on. We had motions to dismiss, expert motions, and motions for summary judgment as well. These arguments were well known, and this argument had never been raised prior to this.
So, counsel, let's go with, for the sake of discussion, that you're right that it was forfeited. And in talking with your colleague, as I understand it, then the question is, was there plain error, which is under I think the Bristol-Myers or some case says no evidence. So you still have to, I think, point to some evidence that Nurse Peck caused these injuries, even if it's forfeited.
Yes, Your Honor.
Do you agree with that?
Yes, Your Honor. I'd like to.
And, I'm sorry.
I just wanted to quickly, under our position, it was waived, not forfeited, I believe is the argument, but yes.
All right. But if it's waived, is it still the same point that it's plain error, no evidence?
Yes, Your Honor.
Okay. Do you agree that no expert said Nurse Peck's failure to adhere to the standard of care caused Bowley's death?
I agree, Your Honor, that no individual expert made that statement. However, that is not the standard here. The jury is allowed to connect the testimony of multiple experts. And so we had an expert state that had Nurse Peck complied with the standard of care, she would have done the four things the opposing counsel discussed. A doctor in that situation, hearing from her, would have referred him to the hospital, and he would have, to a reasonable degree of medical probability, would have been able to be saved.
What's the law that you can, is that right? I mean, I know Nurse Roscoe said that Peck would violate the standard of care by not doing those four things.
Yes, Your Honor.
And what expert said that had Nurse Peck done those four things, a doctor would have referred?
Again, we're not looking specifically at Nurse Peck. We're looking at had a nurse complying, an LPN complying with the standard of care in that instance, called a doctor, as Dr. Bethea testified, a doctor receiving the information that our testimony put on, an LPN in that situation would have held the chest complaints, the low blood pressure, and those things would have, under a reasonable standard of care, had to send them out to the hospital.
But Dr. Harris didn't.
Yes, Your Honor, and that's my next point there is first on the two things on that. One, the inconsistent verdict error has never been brought up in this instance. And Your Honor, I was having trouble finding Fourth Circuit precedent on this, but in many other circuits, there isn't an idea of an inconsistent civil jury verdict for the exact issue you were looking at. Is under a Rule 50A motion, a party is almost never going to interpret or look ahead to make a motion based on, well, if the jury comes back for one of my clients and not the other, or an inconsistent verdict, that would then kind of backtrack that evidence wasn't put on. The point we're looking at here is whether evidence was put on, any evidence at this standard, that Nurse Peck was a proximate cause. But even if we are going to look at Dr. Harris as a kind of stand-in reasonable doctor he was not qualified an expert, but even if we are going to look at that, there is certainly evidence in the record for a jury to have found that his failure for negligence was not because he complied, is not because of the standard of care was wrong the plaintiff put forward, but because Nurse Hayes, another nurse here, acted negligently in providing him with false information. He testified that the information.
But you disavowed that. I mean, Dr. Bethea didn't even suggest that at all. I know you had disclosures that allowed you to do that and made good sense. You settled with her, but Dr. Bethea said if you get the information about chest pain, blood pressure, and pulse, it's all over. Send him to the ER. Yeah, I think maybe you, and I'm not criticizing this at all. The question was, what about the answers or the questions to Nurse Hayes and the answers she gave? Doesn't matter. Send him. It's just that basic information. So there was no evidence put forward by anyone that Nurse Hayes was negligent at all.
Well, Your Honor, again, I have two answers to that. One would be that
you couldn't have. You settled with her. I mean, if you had put forth evidence that Nurse Hayes was negligent, that would have killed your case against Dr. Harris. I mean, so you made the right strategy call, but you can't say they would have found their negligence when you didn't put forth any testimony of that, and you kind of abandoned it for good strategic reasons.
Well, I have two answers to that, Your Honor. One of the reasons we didn't put it on is because this issue was not raised before. Had this issue been properly raised at a Rule 50A motion, we'd been on notice of the ability to put this on. So I think a lack of the record in that instance is exactly the reason why Rule 50A exists in this context, is that we have the ability to correct any of those alleged errors. And secondly,
But you would have then had to decide, and I want to get your second on, you would have then said, okay, there's no expert testimony as to Nurse Peck. I'm going to now put some evidence on that Nurse Hayes was negligent, when you still had a claim against Dr. Harris, which you would have, I mean, come on, you wouldn't have done that.
Well, Your Honor, again, but that would have been our choice. But again, there's two instances. One, I disagree with the idea that we had no evidence against Nurse Peck. Going back to that issue, it would be improper for Nurse Roscoe, Dr. Roscoe, she has a PhD, but is not a doctor of emergency medicine. She's not allowed to opine on causation. She is not qualified to opine on whether or not he'd be safe. And similarly, our causation experts are not qualified to opine on what an LPN standard of care is. This is classic in medical malpractice claims, that this kind of causal chain is allowed. And especially when we're looking here for Dr. Bethea's testimony, there was no requirement that the jury have accepted everything Dr. Bethea had said. Again, we're looking here, even under the most beneficial standard then that they hadn't waived it, we're looking at a reasonable jury could have drawn these conclusions. A reasonable jury can believe Dr. Bethea partially. A reasonable jury can say that he was being too strict, that it was appropriate for, based on as their expert put forward, it was appropriate for him to order more testing, and maybe the jury found somewhere in between the two of those. The point is that this idea that the jury is bound to only accept everything the plaintiff said or not is not how we look at jury verdicts.
Can I kind of follow up on that? Because
yes, Your Honor.
It wasn't in the record, and so but I was just curious, and so I did look at the expert reports, from the district court, and and
the reports talk about how Bethea would testify that the defendants, plural, were, caused the injuries. But at the trial, the only testimony he gave was that Dr. Harris caused the injuries.
Again, Your Honor, it's our position that under Virginia law, under any medical malpractice or negligence law I know of, he does not have to use her name. He said that these cause of chain, that he connected part of the chain, that what she did caused his death. The idea that she, he's allowed.
What's the JA site that Dr. Bethea, where Dr. Bethea or any expert, said that, from which you say there's evidence that includes Nurse Peck's negligence?
Yes, so Dr. Bethea, JA 781 and 815.
Could you be a little, say that? I didn't.
Sorry, JA 781 and 815 as examples, but throughout his testimony, he said that, and I'm paraphrasing here from those two, the standard of care required the doctor hearing of Mr. Boley's condition from an LPN to, quote, transfer him to a center where the appropriate diagnosis and treatment would be available. And you combine that with Nurse Roscoe's statements that an LPN qualifying, following the standard of care would have provided that information to Dr. Bethea. The fact that she failed to do that and failed to communicate is that one step in the proximate cause chain here. In this court, as far as I'm aware, there is no holding under Virginia law that each individual defendant be named. There's the evidence be put forward. The idea that most of their argument on this, I believe, comes down to the idea that Nurse Peck was not named specifically by the causation expert, but I think is being a little bit too fine in.
But it's not just that, is it? I mean, we know here that Dr. Harris did not transfer Boley based on when Dr. Harris knew about chest pains, knew about blood pressure, and knew about pulse. And so carrying things forward, those are facts.
Well, I actually would push back on that a little bit, Your Honor.
Well, I want to hear that, so, because
Okay.
if I got it wrong, I'm open, I want to hear that. But it would, just for the sake of discussion, it would seem to show that Nurse Peck caused this, you would have to show that Nurse Peck would have provided different information than Nurse Hayes would have. Or that somehow the information would, I guess relatedly, the information would have been different, an hour and a half earlier when she encountered him. And so it seems like, that's not just, that's additional. If you accept that Nurse Hayes's information didn't cause Dr. Harris to transfer him, it seems like you got to show that Nurse Peck would have done something different.
Again, Your Honor, I'm going to go back. There's two things on that. One is that while Nurse Hayes didn't come testify, there was a lot of information that came in about what she said through Dr. Harris's own testimony. He testified a lot, attempting essentially to push the blame onto her, which was successful. He testified that she had a lot of information, but it was not adding up, that she told him he may have missed some of his blood pressure pills, maybe taken one more. She wasn't sure what was going on. She provided, potentially the jury could have found that she provided alternative information that he could have ruled that this wasn't that bad. And even when she spoke to him a second time, she said that his chest pain was now minimal, which experts, from our expert testified that with the leaking blood in his chest, that would not have been true. So the jury could have also found that the actual information Nurse Hayes provided to him was incorrect. And going back to my other argument about the two different experts, Your Honor, is that
before you, I promise I'll let you come to that.
I understand, Your Honor.
But before you leave that, that's fair. I read that as well. But don't you have an obligation as the plaintiff to present forth evidence of all your claims, an obligation to present some evidence that Nurse Peck would have done something different?
Yes, Your Honor, and she would have complied with the standard of care. Again, we're allowed to say that she would have, so again, she would have not provided him incorrect information. She would have provided an accurate blood pressure. She would have provided his chest pain and where it was. Again, one of the things that's supposed to be done is a physical assessment, in terms of where to see the pain was, and Nurse Hayes did not do that, or at least a testimony did not come in that she did anything like that.
So you're entitled, you think, to say, based on what Nurse Hayes gave Dr. Harris, he should have transferred the inmate to the ER. And and then say that without saying that, that was inadequate or that Nurse Peck would have done something different, the jury somehow puts all that together?
I have two statements to that. One, again, our statement would be that Nurse Peck would have done something different than Nurse Hayes. No, that's not true. A nurse complying with the standard of care. And so again, because Nurse Peck entirely blew him off, all we have is the ability to put in a reasonable LPN complying with the standard of care and what would have happened at that point. And again, I think I'd like to point out here that our evidence at the trial, of course, our theory of the trial is different than what is now, but again, the jury is not required to accept everything the plaintiff argued. The jury is allowed to pick and choose, and the question here is whether there was either any evidence under, we believe, the appropriate standard, but even if they haven't waived this argument, the question is whether there was some evidence for a reasonable jury to have made this conclusion. And there's nothing unreasonable about the jury, picking a middle ground between the two plaintiff's experts. Maybe the jury believed that had Nurse Peck called at the appropriate time, and then Nurse Hayes had also called later because the doctor had asked for monitoring and provided correct information, he would have sent him then. Maybe the jury found that, maybe they disagreed with Dr. Bethea, they had to go out immediately, but they didn't agree with their expert that waiting until the next day was okay. Maybe they thought that, had an appropriate nurse done a follow-up in 3 hours and said, yes, he still has lots of pain. As Dr. Harris himself said, if anyone had told him that his condition was still worsening, he would have sent him out. And so I think that the idea here is that, as has been gone through, a lot of the arguments here are changing after the fact, because I think what's happening is that the defense is trying to take a position they wouldn't have made at trial for obvious strategic reasons, and are now trying to, take what happened with the verdict and kind of backfill that this would not be possible. And again, I think that under the standard we have here, it's our position that there is, first of all, that they have waived this argument because as the district court who heard the entire trial, heard the oral argument, sat through all this, knew what the arguments were, said, this is brand new. And I think that, and then going back to the plain error standard, what we're looking at here is whether there's some evidence that Nurse Peck, there's some evidence for a jury, a fact question, approximate cause, for a jury have been able to find that her death to a reasonable degree, or her negligence to a reasonable degree of medical probability was a proximate cause of Mr. Boley's death.
How many jurors did you have? Was it 12 jury?
No, Your Honor, it was 8, I believe.
Okay, and...
I believe it might have been 6, I apologize.
All right. And how old was the plaintiff?
The plaintiff was in his late 40s, Your Honor.
Okay.
And just going to...
It's a big verdict.
Yes, Your Honor, it was. However, this was a death case, and as the district court put through, he was getting close to getting out, and there was a lot of testimony from his 2 brothers to which he was extremely close, including the one who is the beneficiary, that they were going to live together. The 3 of them were very close, had a close upbringing together, and again, he was getting out pretty soon and had a chance to, kind of restart his life after a long time.
How long had he been in prison?
It was approaching 20 years, Your Honor.
20 years?
Yes.
So he went in when he was 19 or 20?
He was in the early 20s, I believe, Your Honor. I'm sorry, I don't have those numbers off the top of my head.
No.
But yeah, he had been in for a pretty serious amount of time, Your Honor. Going to the new trial aspect, no, this wasn't discussed much, but there was...
Counsel,
yeah.
I got one more
Yeah.
case. I'm sorry to, make sure I'm just trying to understand all these issues. I appreciate your, responses. The way you finished a response just a second ago was that this proximate cause is a fact question, is that there was some evidence that a reasonable jury could do that. But isn't it true, though, that under Virginia law, I mean, it's a factual question, but it requires expert testimony. So it seems to me the question is, whether there's any expert testimony that Nurse Peck's negligence caused, Dr. or Mr. Boley's death. And so I was just making the point that it's not just like a, simple negligence case where you can look at circumstantial evidence and stuff like that. It's a medical mal that requires that to be not just any evidence, but admissible expert evidence.
Yes,
I know
Your Honor.
we've already been through why you think that is.
I might have one more point. I think the other way of maybe conceptualizing that would be to imagine this case were only against Nurse Peck.
Right.
If this case were only against Nurse Peck and there was testimony that she should have referred him to a doctor, and a doctor saying, in that situation, I get that call, he goes to the hospital, and another emergency room physician saying, he gets to the hospital, he survives. I think we have no question in that instance that there is appropriate, or I would believe our position would be that there's no question that there's appropriate expert testimony, even if the third expert or even the second expert don't say the woman's name specifically or whoever the nurse was, that is enough that the jury is allowed to, there's no requirement under Virginia law that one causation expert or the one expert complete the entire chain, only that there is expert testimony. And again, we are not challenging that as a matter of law, there needs to be expert testimony to establish causation, except for rare instances, which we weren't bringing up in this instance, is our position that that burden has been met and that whether there was sufficient evidence to find, whether that expert testimony was sufficient to find proximate cause is a question for the jury. Once those experts have been certified and do meet the applicable standards under Virginia medical malpractice law, which is not being challenged here, they all do meet that standard.
Last question I have, and is there any expert testimony that had Nurse Peck complied with the standard of care, she would have provided different information from Nurse Hayes?
Yes, Your Honor. Well, I think it's more in the absence that Nurse Hayes provided additional incorrect information beyond the standard of care. Again, the statement about the blood pressure medication she gave, as Dr. Harris himself said, that the information she was giving was not adding up. And so I think the point here is that the information she would have given we can assume would have added up. And we can't know exactly what I see I'm out of time. May I briefly finish?
Yeah, you may.
There's no way we could have known, because she didn't see him, what his blood pressure would have been or what his pulse would have been at that time. But according to our expert testimony and the inference the jury can make, the symptoms would have been roughly similar to what Nurse Hayes saw an hour and a half later. And so again, we can argue that, had she provided accurate information, and complied with the standard of care in a way that Nurse Hayes didn't, that he would have gotten to the hospital, or at the very least had, multiple nurses interacted with him over the day period, that he would have gotten to the hospital.
One question that make sure you know your case. I know it's on the record, but you know your case. Is your argument that basically the expert testimony was for a nurse, for the qualifications that she had and her obligations, these are the things that a nurse generically in that position should do, right? 1, 2, 3, 4.
An LPN, yes,
right?
Your Honor.
And that would be applied to both, one, Peck, and the other nurse as well.
Yes,
right?
Your Honor.
And in this case, there was evidence that, first of all, number one, kind of disavowed, I don't even remember, I'm not even my case, that kind of thing. So, but we do have what the standard would have been had she done those things. But number two, it called in question whether or not it was accurate what number two gave to the doctor, right? If something incorrect and those kind of things. So the causation, I guess, your theory, well, not theory, but the evidence is, had nurse number one, Peck, done what she was supposed to do, you had to presume she would have done it correctly.
Yes, Your Honor.
Yeah, that's the thing. So, yeah, she would have done it correctly. So you don't need another, you have the expert to say what you're supposed to do. And the question is, the jury said you didn't do it. And therefore, but the other one, you can't say, well, you don't have to find anything, I would have done something different. I would have done it correctly, what number two didn't do. I mean, assuming that, right? That's what I
Yes.
thought.
Are there any questions, Your Honors, about the motion for new trial before I sit down?
No, they're not.
All right, thank you very much, Your Honors.
Thank you. Mr. Chancellor?
Your Honor, I believe I used my rebuttal time.
Oh, no, we don't do that in the Fourth Circuit. We still give you your 4 minutes.
Thank you, Your Honor. Thank you. Your Honor, in response to the argument from counsel, I think one important thing to remember, and this is in the record, and this goes to Judge Quattlebaum, your question a few moments ago, is that there is no evidence in the record as to what Nurse Peck would have reported had she seen Mr. Boley and assessed him or evaluated him.
No, the evidence is what she should have done.
Correct.
And there is a standard by an expert that said what they was.
Correct, but under Virginia law, I disagree with the appellee. Under Virginia law, the expert testimony has to look at the procedure at issue, so you have to look at the position and what the standard of care was for that position, and then link that to the proximate cause, the breach of that standard of care for the nurse proximately causing the death. So, for example, if this were a case involving like a bedbound patient, the nurse standard of care might be to reposition that patient every 20 minutes or whatever it may be, so that they don't develop a pressure ulcer. If the patient develops a pressure ulcer, what you then have in a medical negligence case is you have a standard of care expert who says the nurses should have rotated this patient, and then you have a physician who says, yes, the failure of the nurses to rotate this patient or reposition this patient caused this pressure ulcer. That's how you link up proximate cause under Virginia law.
I'm sorry, Judge Gregory.
There is a link. What do you mean? There is a link. It would say that if you had clinical findings, you've done what you're supposed to, you make those clinical findings, you should have reported correctly those to a physician, right? Referral. Is that correct? It's not complicated. It's right. That's the nurse should have done. When you make these clinical findings that he presented with, then it should be clearly a referral to a physician. Is that correct? Can we agree on that?
Or report to our supervisor, it could be an RN. But yes, it should be reported up. For the LPN position, and this is based on Nurse Roscoe or Dr. Roscoe's testimony, is that the report up is to whoever the supervisor is. So in the medical hierarchy,
There's no time to wait for a supervisor. This is life and death. You need to get it to make sure a phisian has it, right?
that wasn't the testimony from Nurse Roscoe. It was to either.
No, but the Nurse Roscoe, in terms of, is that part of the medical standard in terms of these are things you're supposed to do, but I got to find a supervisor before I do it? Is that what you're saying?
Well, under Virginia law, the LPN.
Virginia law doesn't say that. I'm a Virginia lawyer. You know, it doesn't say that you have to find a supervisor where you can say, well, I know what I'm supposed to do. I have these clinical findings, but now I have to go find a supervisor before I can get into, this is a life and death situation. The man drowned in his own blood.
I think, Judge Gregory, maybe I didn't articulate my response correctly.
but
Not
there
to
must be
find
a
I was just saying the supervisor could be a physician or an RN. So it just whoever they're up the chain, they need to report it up the chain is what the testimony was from the expert on the other side.
But your
again,
position was with whatever position you took at the trial, maybe none, but with Judge Nurse Peck, that she didn't do anything because she wasn't involved.
that was her testimony. She didn't see him. That's
Right,
correct.
so she had no defense about any of those things doing it because it was like all or nothing. You got to believe that I wasn't involved. Jury obviously didn't believe that. And now you come in and say that there's a causation problem that you didn't really raise because it was very difficult because there was a different interest there involved.
It was a causation issue that was the plaintiff's burden to establish. And to respond just really quickly, Your Honors.
Is it the law that all inferences are drawn in favor of the jury verdict? All reasonable inferences are drawn in favor of a jury verdict?
In the light most favorable to the plaintiff, yes, for the prevailing party,
That's
yes.
right.
But just to point out to Your Honors, the plaintiff's testimony from their expert was that Mr. Boley had a change in circumstance. My time's expired.
Go ahead, finish your thought.
Mr. Boley had a change in circumstance from the time that he went to see Ms. Peck to when he was seen by Ms. Hayes. And if you look at Dr. Kundi's testimony at trial, he talks about what sent Mr. Boley to the floor when he laid on the floor and was finally seen by Ms. Hayes was this drop in low blood pressure. And he attributes the significant low blood pressure that Mr. Boley had at that time to why he was laying on the floor. And so for that reason, the jury could only speculate what his condition might have been an hour and a half earlier if that's when he tried to go see Nurse Peck. And so for that reason, there couldn't be sufficient evidence on the proximate cause, and we would ask that the district court's ruling on the Rule 50 motion be reversed.
Okay, thank you both.
Thank you.
Thank you both. We'll ask the clerk to adjourn the court until tomorrow morning. We'll come down and greet counsel.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
We coming back?
Constitution Day program.